It's very good to see you all here, and thank you very much for coming all this way to Garden Court. So, the conversation I had with Aisling the day, I think, of the Act coming into force, I'm ashamed to say, is what made me look at this piece of legislation, when I'd been burying my head in the sand up until then. So it's been very useful to have had to kind of grapple with the Act if nothing else is useful about. But anyway, what we plan is going to aim to speak for about 20 or 30 minutes at most on a range of topics. I'm going to start with Isaac, who's going to talk about removals and appeals under the Act. Then Greg and Gordon are going to talk about detention and challenging detention. And Georgie, who is currently trying to get back here from Hatton Cross, hopefully will be back in time to talk about children and provisions specifically affecting children. I'm then going to talk about asylum and protection claims and judicial review claims. And then lastly, Emma, and hopefully also Gemma, who is presently detained in Birmingham, but hopefully we'll be back in time, we're going to talk about trafficking. And I thought the only possibly good thing that I found when reading the Act was the promotion of first-tier judges to upper tribunal judges. So I imagine you've probably had a party at Wilson's for Matthew and Michael, who are now upper tribunal judges. But anyway, having said all of that, and I think we're expecting food to be delivered around about 6-ish. I think we'll probably have a break around about 6-ish, something to eat and something to drink, and then carry on again after that. So with that, I'll hand over to Isaac.
Hey everybody, my name's Isaac. As you can see on there, as Ronan said, I'm going to be talking about removals under the 2022 Act and also about the ways that you might challenge removals under the 2022 Act. So I'm sure you'll all be aware, obviously, that the Act is extremely draconian and unfair in terms of removals. I don't know how many of you have read all of the provisions, but if you haven't, you may not know that they're also very confusing and a lot of them don't really make any sense. But I'm going to try and make them make sense as much as I can by breaking it down one step at a time. So I'm going to try and focus on kind of steps that you need to go through with a client, right? So firstly, I'm going to talk about the duty to remove and when that applies. And then there are kind of a couple of groups that are either always or sometimes exempted from that duty. So we'll talk about that a little bit. And then I'll talk about what the consequences are when the duty applies to a client. And then fourth, about the ways that you might challenge removal. And there's two separate regimes for challenging that we'll get onto. So one is if their Home Office is trying to remove an applicant to their own country, and another is if they're trying to remove them to a third country, so most likely Rwanda. And then lastly, we'll talk about suspensive claims, which is one of the ways that you will challenge removal, but is obviously a completely new concept under this Act. And so we'll go a little bit of detail into that. So the first thing to say is that the duty of remove is in Section 2. It's not actually in force at the current time. So at the moment, there is no duty to remove. That makes sense because obviously the Home Office doesn't really have returns agreements with any countries. And at present, they can't remove anybody to Rwanda. So if the duty was enforced, then they'd basically be constantly in breach of it all the time. That being said, if the Secretary of State wins the appeal in the Supreme Court on Rwanda, it's likely that this will be brought into force. And so obviously we need to be aware of the effects that it will have. And basically there are 4 conditions that have to be met for the duty to remove to apply. So they're on screen. The first one, there's actually a few more conditions than is listed there, but the most obvious one is going to be that somebody entered the UK without leave to do so. There are also other conditions relating to people who use deception or people who are excluded for financial money laundering regulations or other things like that. But the most common one is going to be that they've entered the UK without leave. The second condition, as you can see, is that they must have entered on or after the date the Act came into effect. So that's the 20th of July this year. Third condition is that they must not have come directly to the UK from a country that they were at risk of refugee convention harm, and we'll come back to that in a moment. And the fourth condition is that the person requires leave to remain in the UK or to enter but doesn't have it. So those are kind of the basic conditions. And in my opinion, there are kind of three things just in section 2 itself that it's worth remembering. So the first one, as you can see on there, is the date that the applicant must have entered the UK. So when the Act was just a bill, it was thought that it was going to be retrospective to the 7th of March. So it's improved in that respect at least, in that it catches a smaller cohort of applicants. And the second thing is that section 3.1 gives the Secretary of State a power to amend that date further. What's important about that is that section 3.5 makes clear that any amendment can't set the date further in the past, so it can't retrospectively expand the cohort, it can only put it forward. And you might wonder why the Secretary of State would want to do that, given she wants to remove as many people as possible, but the reality is that whenever this comes into force, there's probably already going to be quite a big cohort of people who arrived since the 20th of July, who she is then under a mandatory duty to remove. She's in breach of her legal duty whenever she doesn't, and so she may think that it's easier to start it a bit later than to have a massive backlog of people that she has to remove. That's obviously all conjecture really at this point. It may not be amended, but if it is, it will only be moved further forward. And then the third thing to say is that condition 3 is obviously intended to ensure that the duty applies to anybody who has gone through any other country on their way to the UK. So effectively, it's directed at small boats cases. That's what this is for, as we all know. And in trying to catch those cases, the Act adopts the language of Article 31, which is in that it says that the person must not have come directly. And the reason that it must have done that, I think, is probably to avoid it being contrary to the Refugee Convention, because Article 31 says you can't impose penalties on people who do come directly. The difficulty with that, as you can see sort of flagged on the screen there, is that the Act has kind of radically altered the concept of coming directly from what it's traditionally been understood as. So in international law, it was always understood that people could pass through or stop in another country, and that as long as they weren't effectively settled, not in a long-term sense, but settled in some form in that country, they would still have then come directly to the country they end up at. And that reference, which is on there, is a UNHCR report which says exactly that. So that's kind of always been a settled understanding. The 2022 Act already kind of narrowed that a little bit, as I'm sure you'll all know. So it said that they could not have passed through another country unless they had reasonable grounds not to have claimed asylum there. So that was already kind of a narrowing of the protection for refugees. It's now got even narrower. There isn't a single exception like that in the Act. So in fact, the Act expressly says at section 2.5 that a person is not to be taken to have come directly if on their way from their home country they, quote, passed through or stopped in another country where their life or liberty was not threatened. So if they stopped anywhere at all, the intention of the Act is that they fall under this duty to remove. See, that might be susceptible to challenge. You think it could well be, but unless and until it is challenged, the intention of the Home Office will, I think, be to apply it to any person who's ever stopped anywhere else. So that brings me to the second subtopic, which is exemptions from the duty to remove. So the first and only group that is completely exempt is unaccompanied minors. The definition for that is in section 4.5 of the Act, and you can see it on screen there, but basically it's someone who's under the age of 18 and who doesn't have anybody who has care for them, whether that's a parent or not. What section 4.1 says is that the duty to remove does not apply at a time when the person is an unaccompanied child. So in other words, the duty goes when they're a child, and then as soon as they're 18, it arises again. So hypothetically, you hit 18 and the Home Office would then try to remove you. And that's confirmed in section 6.1b, which you can see on the slide there. And the other thing to note about this is that even though there isn't a duty in respect to unaccompanied minors, there are circumstances in which the Home Office may still remove unaccompanied minors. She has a power to do so. I don't understand that there's a policy yet on when she would do that, but that's certainly available to her under the Act. But one of the three conditions on screen, which is in section 4.3, has to be met. So the most obvious one is removal to reunite a child with their parent. But then there's two other categories. The first one is if they're from a country that's in the new section 80AA, which was added by this Act, and that's basically EEA countries plus Albania, then they can be removed to that country.
Regardless of a protection claim.
Yeah, so if they're from that country, the one on that list, then yeah.
So they'll be treated the same as an adult.
Yeah. Whereas if they have made a protection claim and they're from those countries, then yes, they're treated the same as an adult. If they're from a different country, then if they make a protection claim, they won't be removed to those. They'll only be removed. Yeah, that's right. Thanks. So the other potentially exempted group is trafficking victims. Emma's going to talk a little bit more about that. They're not really exempted. It's probably not right to say that they are, but in some very narrow circumstances they may be. The relevant section is section 22, and essentially the question is whether they're providing assistance to the Secretary of State at that time or to the police authorities, and it's necessary for them to remain in the UK to do so. Otherwise, if the Secretary of State thinks it's not necessary, even if they're helping the police at that time, they could be removed. But Emma's going to talk to you about that in more detail. And then the final category is potential other groups that the Secretary of State may name by regulations. There's a power in section 4.7 to exempt groups. No indication, as I say, on the use of that power yet, but Robert Jenrick was asked a question in June about what would happen to people from Afghanistan who would have qualified under Arab. He didn't say we're going to use the power for them, but he said, well, we've got this power and we're considering how to use it. So that's maybe an indication of the kind of groups. And obviously that would be in itself a positive step. So that brings me to the next question, which is what the consequences are if the duty to remove does apply to your client. So I'm not going to be looking at the duty to detain, which Gordon and Greg will be talking about. The first thing that I want to talk about is what I call disregarding certain claims in the headline. The reason I say certain claims is because this duty doesn't apply to human rights claims about removal to a third country. But if you make an asylum claim or you make a human rights claim that says you shouldn't be sent back to your own country, then under section 2.2 and section 2.5 of the Act, the Secretary of State has to declare it inadmissible. There's no discretion there, straight away, immediately declared inadmissible. And as a consequence of that, as per section 5.3 to 4, the claim won't be considered and there'll be no appeal right whatsoever. So effectively what's happened there, the practice of appeals against asylum law decisions has been got rid of for the vast majority of people who didn't enter the UK lawfully, which of course is almost all the asylum seekers. It's slightly ironic, obviously, because the reason that the appeals were introduced was to avoid lengthy and costly JRs, which it seems now will be much more common. The other thing to say is that you can JR decisions, but the duty to remove will continue to apply even whilst the JR is outstanding. So it's not suspensive. And as we'll come on to a little bit later, and I think Ronan will speak about more, the Act under section 64 prohibits interim relief that prevents removal. We'll come back to that later, but essentially, even if you do JR a decision, it's not going to in itself be able to prevent you from being removed whilst that JR is heard. And then the final thing on this slide is about human rights claims in relation to a third country. So if they're trying to remove you to Rwanda or something similar than that. As I said, you can make those human rights claims still, and they're not subject to a duty to declare inadmissible, so that the Home Office will consider those human rights claims. Section 41.4 makes clear that there's no appeal right in respect of that. And again, section 5.1b says that the duty to remove continues. So you make a human rights claim, they'll consider it, fine, but we're going to remove you to that third country whilst we work it out. And then the second consequence, main consequence of section 2 applying and the duty to remove applying, is that the Secretary of State is under an obligation to remove the person, quote, as soon as reasonably practicable. It's not said precisely what as soon as reasonably practicable means, but it's similar to a best endeavours duty or something like that, is what it seems like on its face. And that begs the question of where the Secretary of State will remove to. And section 6.3 gives the 4 places that she may do so. The first one is their own country. The second one is a country they have a passport from. Third one is the country from which they embarked to the United Kingdom. And the fourth is a country to which there is reason to believe that the person will be admitted. So again, that in the Secretary of State's ideal plan is Rwanda at the moment. The only thing to say about that is that there are two important categories of exception to that list. So there are exceptions for people who come from the EEA countries and Albania, and they're in section 6, 4 to 7. And then there are exceptions for applicants who come from any other country. So dealing with applicants from the EEA or Albania first, a person can ordinarily be removed, as I say, either to their own country or to a safe third country. There is an exception to that. The Secretary of State accepts that there are exceptional circumstances that mean they should not be sent to their own country. So that exceptional circumstances test under section 6.4 only applies to their own country because it relates to the protection claim. As I say in the next bullet point, there's a list of potential exceptional circumstances at section 6.5. They're very narrow. They basically are where there's a formal derogation from the ECHR or where there's formal action being taken by the Council of Europe or the EU for breaches of human rights. So they're almost never going to apply in any claim that you have, but they are expressly non-exhaustive. And as it says in the third bullet point, in my opinion, it must be the case that exceptional circumstances can be read much broader than that. It must be able to include an individual's particular facts and evidence if that discloses a very clear case of a risk of harm. So obviously you're going to run into the difficulty that you're going to have to front load that case so much that at the very, very early stage you could, well, given that they've just arrived and they've probably received a removal notice about a few days after that, so it sounds fun, but you're going to have to essentially front load that case somehow to show that there's a very, very clear positive case. You're going to have to put that before the Home Office and hope that they accept it. And there are two reasons why I say, at least in theory, they should potentially accept that some cases reach that. The first is that exceptional circumstances case, as I'm sure you'll know, is not a new test in itself. So it's applied to EU asylum claims under the immigration rules for a fairly long time. I've worked on one case where a case was admitted to the procedure based on its very strong facts. So it obviously is possible, albeit very difficult. And in those circumstances, we had a much longer time period to do it. So it's not to say it will be easy, but it should at least be possible. And also, as I refer to on the slide, there is case law that supports that it should be possible. That case of ZV does set a very high threshold. It says that there needs to be compelling evidence to believe that there's a clear case that the appellant would be at risk. So it's a difficult threshold to meet, but it is surmountable in theory. And I think Ronan will talk more about that in the context of Albanian cases a little bit later. And the second reason that I say that exceptional circumstances must be capable of embracing particularly strong facts is that if it wasn't, it's effectively impossible, as far as I can tell, to see how the legislation could be lawful. Because it's one thing, possibly, to create an irrebuttable presumption of safety for countries in Dublin, but to say that you can't rebut a presumption of safety about Albania, given obviously what we all know about the level of claims that are already admitted and accepted, seems like it would just be plainly unlawful. So there is probably room for challenge to these provisions if the Secretary of State doesn't accept that they're drawn in that broad way that we say they're drawn, but nevertheless it's going to be a very difficult threshold to overcome.
And if you sway them, there's exceptional circumstances, then that just puts you in the safe third country.
Essentially, yes. So then, so I'll get to that, but basically that means you can't be sent to your own country. So then you go in the pot of people who can be sent to safe third country. And then you have to challenge the removal to a safe third country through a human rights claim and then likely a suspensive claim and then an appeal. So yeah, it moves you from kind of, if you're an Albanian national, from the worst pot into a slightly better situation, but then there's a whole other layer of challenges that you're going to have to bring for sure. When you're dealing with non-EEA or Albanian applicants, the position is a little bit better. So Section 6(8) to 9 makes clear that they can't be removed to their own country if they make a claim to asylum. So if there's an asylum claim, they won't be returned to their own country. And the reason for that obviously, is to prevent a fully genuine refugee. Both cohorts, however, and this is the thing to remember, this is the point that you already made, will still be subject to removal to a country listed in Schedule 1. That's wider than just EEA states. It also includes Rwanda, and it includes a lot of other whitelisted countries as well, in the event there was an agreement with those countries. So this follows on from your question, really, but it brings me to the next thing, which is how to challenge removal. So the first question is, if your client or an applicant is proposed to be removed to their own country, how do you go about challenging that? So as I've said, this is only really likely to arise for Albanian clients, other EEA clients potentially, but there's likely to be fewer of those, for the reason that an asylum claim will put non-EEA and Albanian applicants out of the pot of people who could be removed there. Now, the only route to challenge, as far as I can tell, is to judicially review the Secretary of State's failure to accept their exceptional circumstances. So as we said, there's a high threshold set in ZV, but it may well be achievable in Albanian cases because of all of the evidence in our favour, really, including the outstanding and still enforced country guidance. So Ronan, again, I think will talk more about that, and David Neal's produced some slides. The problem with that is that unfortunately that's not going to be the end of the road for your client. On the third bullet point, it says why that is. But basically, even if you do have a strong case for judicial review, on its face at least, the Act makes it impossible to prevent removal while that judicial review is heard. And that's so for three reasons. The first one is that judicial review is itself not a barrier, as I've said, so that's section 5(1)(d). Second reason is that although suspensive claims do exist and are created by the Act, they only relate to third country removals. That's the definition of a serious harm suspensive claim in section 39(2) says removal to a third country, so it doesn't appear to apply to removal to a person's own country. And the third reason is that interim relief is prohibited under section 64. So on its face, there isn't really any avenue short of completing a judicial review, which would of course prevent it, but other than doing that, there's no avenue to prevent removal to a person's own country. So we're likely to be in the position, well, one, there will never be a challenge to that, and in my view, such a challenge would be relatively, maybe not likely to succeed, but have good merits, because it's hard to see how that could be compatible with the Human Rights Act, given you might be returning Albanians to a site of serious harm, persecution, Article 3 harm, and so on. But short of a challenge, a successful challenge against any of those provisions, we're going to be in a position where you need to try to bring a judicial review and finalise it through the most expedited timetable you could imagine before the removal date is due to be. So that's up to a point of final hearing, final relief in 2 weeks or whatever it is. So how the Secretary of State thinks the courts will be able to cope with that, I don't know, but that is the position as Matt stands. So then the second question is, if you're not being removed to your own country, either because you're not in that pool initially or because the Home Office accepted there's exceptional circumstances, you then obviously need to challenge removal to the proposed safe third country, whatever that is. So as it says on the slide, the first step here, you want to make a human rights claim. And as I said earlier, unlike a claim related to a person's own country, there's not a duty to disregard or declare that claim inadmissible. That's section 5(5). So the Secretary of State, it's clear from the legislation, will consider a human rights claim in respect to the third country. And even though there's no appeal against a refusal, you can, as I've said, JR a refusal of the human rights claim, and you can run your human rights claim in that avenue. But unfortunately, that brings us back to the problem again, that the Section 2 duty to remove continues to apply. So it continues to apply while there's a human rights claim, and then it continues to apply while there's a JR. So the Secretary of State's position here, as with actually the Albanian claims, even though it seems possibly even more ludicrous there, the Secretary of State's position seems to be that people can be brought back once they win their JR, if they do.
What about brought back as interim relief? Do you think that?
Well, I think there's no. I think if Section 54 says that the courts can't impose interim relief to delay removal, technically, I suppose you're not delaying removal if it's already happened. But that's an interesting question.
They could remove you again, then, couldn't they?
Yeah, I suppose they could just keep removing you, and then the courts can't do anything, and then you're removed, and they could bring you back. I mean, it's not. it's not expressly excluded by the Act. So I wouldn't be able to say whether it's possible. I'd imagine the Secretary of State would argue that the intention of the Act was to prevent any kind of interim relief that interfered with removal, which that would be said to be. But it certainly would be something to consider, I think, if you were in that position. Obviously, more generally, the kind of idea of getting a bring-back order after the claim is finalised might be relatively unproblematic if it's just not a claim or something similar, right? Because family life can be rebuilt after 2 weeks, a month, however long it is. It's obviously a lot more problematic if, for example, your client says that they're going to die when they're removed because they can't get medical care. So what the Secretary of State has done through this legislation is created one statutory safeguard which is intended to prevent against that, and that's the suspensive claims. So they're intended to prevent a person being removed from this jurisdiction for the time it takes to determine a human rights claim and a judicial review, if removal for that period would cause, quote, serious irreversible harm. So the relevant part of the Act is sections 38 to 50. There's a lot to unpick. I've kind of gone through it in some detail, and in my opinion, there are basically like 10 things. There will obviously be a lot more things, and if anybody has any questions, I could try and answer them. But these are like the 10 really key things that I thought we should be aware of when we're dealing with these claims. So the first one is that these claims are suspensive. I mean, the clue's in the name, so it's not too surprising. But in line with section 47(1) of the Act, they prevent removal throughout the period listed in those bullet points. So throughout the period that a person is entitled to make a claim, although if the applicant notifies the Secretary of State that they don't wish to make one, that protection is removed. And obviously there are potential problems with that in itself, given it could be orally or in writing, and there may be issues with representation and any number of people accidentally saying they don't want to make a claim when they do. But setting that aside, generally, whilst a claim is entitled to be made, which we'll come on to, but it's basically 8 days, the person won't be removed. Then, if you do make a claim whilst you're awaiting a decision from the Secretary of State, the person can't be removed. And then if the Secretary of State refuses the claim and you lodge an appeal, they can't be removed for the duration of that appeal. Now, the whole timeline for that is incredibly truncated, so I'll come on to it in detail in a bit, but the intention appears to be that would take a matter of weeks, the whole thing. Maybe month, but very, very short period of time. But nevertheless, that is a period of time when your client will be safeguarded from removal. The second point from the legislation is that in line with section 38(2), there are 2 types of suspensive claim. So the first one is a serious harm suspensive claim, and that's what I've already flagged. And then the second one is called a removal condition suspensive claim. So in the bill, that was called something like a factual error claim, but basically it's where you just respond and say, actually, there are basic things on this removal notice that are wrong. You know, my client didn't enter illegally, my client does have leave to remain. Something very basic like that. I think its intention is to be of that level, as opposed to factual conclusions about the strength of my client's claim or anything like that. And because those are simpler, and because also they're possibly less likely to arise frequently, the rest of what I'm going to talk about focuses on serious harm suspensive claims, which are much more complex and I think much more likely to arise. So the third thing to remember is that a serious harm suspensive claim is limited to individuals with a third country removal notice. So I've already made that point, but you can't make it in respect of removal to your own country. Fourth thing is that a serious harm suspensive claim is required to argue that before the time it would take to make a human rights claim, to receive a decision and to bring a judicial review, the applicant would face a real, imminent and foreseeable risk of serious and irreversible harm if removed to that country. So the Act actually uses the phrasing of relevant period, but then it defines it as meaning those 3 stages. I couldn't say how the Secretary of State intends to determine how long that will take in order to decide whether serious harm will arise in that time. There isn't any guidance on that, but assumably she'll make an estimation of how long it will take to make a claim, have it refused, and to do a JR. The fifth point is that section 39(4) of the Act defines what serious and irreversible harm can include. It's not expressed as an exhaustive list. So you could think of other examples, but it's all of the things you would expect to be there. So it's Article 2 harm, Article 3 harm, persecution in that country or onwards, referring on to a country where there would be a risk of any of those same things occurring. The sixth point which follows from that is that this is obviously a very high threshold to be able to reach in relation to a third country that is not the primary site of persecution for your client. So to take Rwanda, for example, the current litigation at the moment, as you'll be aware, has succeeded on the basis that there's a risk of onward refoulement. But if the Secretary of State succeeds in overturning that, it's quite difficult to see on a person's individual facts what they could put forward to show that Rwanda, for example, would reach that level of harm for them. The obvious class of case that might, if the facts are really strong, is medical cases. Now, the Act tries to limit the relevance or the availability of medical claims as much as possible. So sections 39.5 and section 39.7 try to limit the ability of an applicant to rely on those. Section 39.5 says that harm resulting from a different standard of healthcare, including a less favourable prognosis, will not be serious and irreversible harm. And section 39.7 says that pain or distress resulting from the loss of medical treatment is, quote, unlikely to constitute serious and irreversible harm. So that's obviously the Secretary of State trying to narrow down the scope to make those claims, but my opinion, just from reading the legislation, is that that's not going to exclude cases that meet the Papashvili threshold that we would all expect to have to meet anyway. So I think it does remain open, and the Act, if it tries to, doesn't successfully close down the possibility of making a claim that reaches that very high threshold anyway. But beyond that, it is quite difficult to see what exactly you'd be able to present in respect of a, quote, safe third country. And then one other thing to note about the threshold is that the evidentiary requirements are deliberately set at a very high level, although what exactly that means is unclear. So section 42.5 says that your claim must contain, quote, compelling evidence. I mean, that could be argued doesn't really add anything, but it's clearly an indication that the Secretary of State intends to treat these very harshly. Seventh point, which has kind of already been alluded to, is that the time limit for making one of these claims is very short. So section 42.7 says that you have 8 days from the provision of the removal notice to make such a claim. Section 42.6 gives the Secretary of State the power to extend that period if she wishes, but there's no real indication of what circumstances would lead her to do so. You would presume that a policy may be published at some point of what would be sufficiently compelling circumstances, but at present I don't understand that there is. If you then miss that deadline, so you don't get a claim in within 8 days, then there's pretty severe consequences as a result of that. So you're not precluded, an applicant's not precluded from making a claim after that point, but section 46.2 says that the Secretary of State will only consider a late claim if she considers that there were, quote, compelling reasons for the delay. The word compelling is used a lot in this statute. And again, it's not clear exactly what compelling reasons will be, but you would imagine that, I mean, it's unclear even whether not having access to legal advice would reach that threshold, but certainly you'd need to be able to provide some reason why the applicant couldn't get that earlier. And then if the Secretary of State does not accept that there are compelling reasons, you can go to the upper tribunal, who can make a declaration that there are compelling reasons. Section 46.5 says that that can only be on the papers, and that's in all cases. There's not even an exception for where the interest of justice requires, so you just make an application on paper. The upper tribunal will then consider it. If they agree with you, the Secretary of State has to consider the claim. If they disagree with you, that's basically it. So there's no right of onward appeal. It's expressly excluded in the statute. And as we'll discuss a little bit later, judicial review of a decision of the upper tribunal on this question, on whether to extend time, is excluded by an ouster clause. So subject again to legal challenge to any of those provisions, if the upper tribunal doesn't agree that time should be extended, that's the end of the road. The eighth point is that the Secretary of State, once she has an application, again, is required to make the decision very quickly. Says that she'll do it in just 4 days. Though again, section 42.7, she does have power to extend that. So in considering the application, she'll obviously be required to consider the evidence that you put forward, but there are also 3 prescribed matters in section 42.4 that she'll have to consider. The first one is any assurances given by the country in question. Second is any support and services, including in particular medical services provided by the government. And the third, which is completely confusing and I don't understand what it means, is the fact that an applicant has not provided certain evidence in circumstances where it would have been reasonable for them to provide that evidence. I don't know what evidence they know should be provided without it being provided, but there you go. So the Secretary of State then has to decide either that the serious harm condition is met or it's not met. And if it's not met, she can certify the claim if she wants to. That's the standard clearly unfounded test. And the ninth point, the penultimate point on suspensive claims, is that the Secretary of State's decision on the suspensive claim will unsurprisingly have serious consequences. So if she accepts that the condition applies, then the person will not be removed to the relevant third country. That's section 47(2). If she does not accept that the condition applies, then you can appeal to the upper tribunal. But the thing to say about this is that this is on a highly curtailed basis, so it's expressly not a full human rights appeal, and section 48 of the Act tightly circumscribes the tribunal's ability to consider any new matters in that appeal. So basically, the tribunal will be considering the same thing that the Secretary of State does, i.e. is the serious harm condition. And under section 44(4) to 6 of the Act, the upper tribunal is obliged to consider the same things the Secretary of State has to, so assurances, medical care and things like that. If the Secretary of State certifies the claim as well as refusing it, then it becomes even more difficult to bring an appeal because you don't JR that decision, but you have to apply to the upper tribunal for permission to appeal to the upper tribunal. That's section 45(2). And the test that the upper tribunal has to apply to determine permission is basically quite bonkers. It is that permission will only be granted if the upper tribunal considers that it is, quote, obvious that there is a, quote, real risk of serious and irreversible harm. So they're piling sort of a few contingencies on top of each other, and what that means will be for the upper tribunal to determine in due course. It's hard to see what obvious necessarily adds to real. And then the 10th point, final point, is that upper tribunal decisions to refuse appeals can be appealed to the Court of Appeal on the same basis as ordinary appeals. So section 44(7) refers to section 13 of the TCEA 2007, which obviously then refers on to the order. So there's an important point of principle: you can appeal a refusal of your appeal. But if you're certified as clearly unfounded, and the UT refuses permission to appeal, there's no possibility of onward appeal. That's section 45(7). And in addition, section 51 expressly ousts the jurisdiction of any other court to review the legality of the upper tribunal's decision on permission to appeal. Now, it may be possible, and one imagines that ouster clause will be challenged by somebody at some point under very well-established principles. I would just note, in terms of considering that challenge, the decision in O Ceallaigh, if anybody isn't aware of it, which deals with a very similarly worded ouster clause in the Judicial Review and Courts Act 2022. I presume the drafters of this legislation deliberately adopted the wording in that clause, but it's basically the same. And it was held that that clause was effective and not unlawful. So the prospect, it's a very different concept, right? Context. That case, O Ceallaigh, I can't actually remember the facts, but it was about something considerably more mundane than the removal of people in breach of their convention rights. But nevertheless, that's the most recent authority on ouster clauses worded in this way. So it's just something to bear in mind if you are considering challenging that. Thank you.
Thank you.
Well, after that really brilliant description of the really grim position, Greg's going to bring some good news about detention.
It works now. It works more effectively than my attempts to get amendments into the bill. I did a bit of work on this, on the bill, which was hugely ineffective. It was really striking that even the reports in the newspapers didn't really refer at all to the changes to hardialising. There was almost no reference to it. In fact, no reference that I saw. And even most of the campaigning didn't engage with that at all. But the changes to hardialising are potentially huge for our clients. Just to clarify this stage, Gordon's going to do most of the, well, with the new powers, I'm going to do changes to hardialising. And what the Act purports to be doing is codifying hardialising 2 and 3 and codifying grace periods, so basically all the stuff in O Ceallaigh, Georgie Rea. And that's what I want to have a quick look at. I'm going to be a lot quicker, hopefully, than Isaac. I think this is quite straightforward compared to what he had to deal with. Hardialising, I'll put it up there because I'm sure most of you are very familiar with, but not everybody will be. So hardialising is a case 1983, actually, before 1984, which was done by Terry Munyard, who just retired from these chambers. It's the only immigration case he ever did, which might be why he brought it against the governor of the prison rather than against the Secretary of State. Anyway, the principles established in that case were codified by Lord Dyson in the case of I, and that codification has been approved repeatedly, most importantly in Lumba, but over and over again. And says there are 4 hardialising principles that are the common law limitations of the right to detain that the Secretary of State has across all her powers. First, the Secretary of State must intend to deport the person and can only use the power to detain for that purpose. Second, a deportee may only be detained for a period that's reasonable in all the circumstances. Third, if before the expiry of the reasonable period it becomes apparent that the Secretary of State will not be able to effect deportation within a reasonable period, he should not seek to exercise the power. And fourth, the Secretary of State should act with reasonable diligence and expedition to effect removal. And almost every word of those 4 principles has been litigated in one case or another. So it applies to the 1971 Act, powers to examine a person for the purpose of removal under Section 16, or Paragraph 16 of Schedule 2, the deportation powers in Schedule 3, and Julie Anderson successfully argued for a while that they didn't prevent removal in certain circumstances, but that's been dealt with. Applies to the UK Borders Act and powers as modified so as to mean that the Secretary of State must attempt to deport the person and can only use the power to detain for the purpose which would include deciding whether to deport the person. So those are the 4 that apply as things currently stand across all powers of immigration detention. Key features of hardialising. One, and possibly the most important, is that in determining whether there's a breach, the court will make findings of fact and decide for itself whether a reasonable period has been exceeded in all the circumstances. So the court will examine, all of the facts, including going through, if you've ever done one of these cases, the GSID records, notes of caseworkers to their more senior caseworkers, detention reviews particularly, everything. They look at everything and decide for itself whether a reasonable period has been exceeded by reference to all the relevant factors. So I don't need to go into detail, but things like how long you've been detained, what risk you pose with absconding or committing offences, whether you've been cooperating with removal, that kind of stuff. That assessment is on the basis of information as it presents itself to the Secretary of State for the Home Department, following the decision of Sales in the first instance in 2009. That's been approved repeatedly since. So the court will look at the facts, but the facts on the basis of the information the Secretary of State has. So if, for example, your client couldn't be removed to the country in question because that country ceased to exist, or he in fact turns out to have nationality that nobody knew about at the relevant time, that doesn't count. There's no hindsight. What matters is what information presented itself to the Secretary of State at the time. And what's said in Lumba by Lord Dyson is that the hardialising principles only do that what Article 5(1)(f) does. They require the power to detain to be exercised reasonably and for the prescribed purpose of facilitating deportation. So as a result of that statement in Lumba, which was obviously approved by a majority of the court, Article 5 generally doesn't add a lot in immigration detention cases, particularly JORs. So generally speaking, not always, but generally speaking, you don't get anything else extra out of Article 5 because you've got the hardialising principles which cover most of the relevant bases. Now, grace periods. The other thing that the Secretary of State was looking at codifying, or the Parliament theoretically looking at codifying here, is grace periods. Now, in the case of FM, the Court of Appeal identified the concept of grace period, told that reasonableness, and Hardy was saying, applies equally to the moment of practical termination of detention as it does to the decision of whether to detain at all. And it's a good example of hard cases making bad law. So the point in FM is you had quite a vulnerable woman with 2 very young children, and the question was whether or not, once detention had been established to be lawful, she'd be immediately released to the streets of these kids, or whether they had to try and find somewhere to put her. And the court said, well, detention isn't unlawful. Immediately at that stage, you have a reasonable period in which to find an appropriate method of releasing a person safely. That then, of course, gets codified essentially, or in case after case after case, holds that the Secretary of State kind of has a grace period for when detention is no longer lawful, and at that stage, they need to start thinking about putting people in accommodation. Typically, you'd say, we used to say 24 hours, 48 hours, but it's gradually expanded over the years. Now you get a week or 2 weeks, sometimes I've seen 3 and 4 weeks, even potentially longer. In fact, AC Algeria was even longer. Altogether, although that's not quite how I tend to describe it in my grant. The grace period in AC Algeria, which is now the leading case on this, is 2020 case that Ranji did, describes the grace period as the period of time allowed to the Secretary of State once detention has ceased to comply with the Hardy State principles to make suitable arrangements for release. And Lord Justice Irwin said in that case, once those principles have been breached, detention is unlawful. It can only be continued for a reasonable period to put in place appropriate conditions for release. The duration must be judged in the facts of the case. It can be very fact sensitive. No risk of further offences can justify preventive detention, which would of course be a breach of Hardy saying 1. It should be stressed that it's the Secretary of State's legal obligation to release the detainee when detention is no longer lawful. There can be no question it's proper for officials to avoid the decision until compelled to release by the courts, imagine. When the question of a period of grace arises, or might arise, the respondent should be expected to advance some evidence and to make consider submissions as to what period would be appropriate and why. So the Secretary of State needs to turn up and show why it is that they need 3 weeks to find jurisdiction, initial accommodation, or whatever it is. And you will agree. I mean, I did a case of this a month ago, and we said, you need to let them out now. They said, no, we need to start looking for accommodation. And we said, well, you can have 3 days. And they said 3 weeks, and eventually we got 2 weeks, and that's sort of what happens. In circumstances where, like in that case, you couldn't really risk going to an interrelief hearing because we might not have won. One thing noticed about grace periods is that it's highly doubtful that this is an accurate interpretation of how the common law stands. I mean, we're talking about Schrodinger's lawfulness, basically. I mean, it's either legal to detain them or it's not. You can't have a situation whereby you've exceeded the bounds of the common law justification for detention, but you also get an extra little bit because you didn't look to find appropriate accommodation beforehand. Like, it's really problematic, this. And there are other problems with it, which I'll get to in a minute. Section 12, clause 12 as it was. Changes in Hardy are really significant. So a person detained under all of the detention powers may now be detained for such period as in the opinion of the Secretary of State is reasonably necessary. So that's what Hardy 2 and 3 are now. Whether or not there is anything that for the time being prevents removal or deportation. So I think what they're thinking of here is the fact that Chinese authorities will not take you, the Cuban authorities won't take you, you have no chance of getting a Moroccan ID or a ETD, whatever it is. And in circumstances where it's accepted that removal or deportation can no longer be achieved in a reasonable period, you can be detained for such further period as in the Secretary of State is reasonably necessary. So codification of grace periods, but also now not what is a reasonable period, but what the Secretary of State considers is reasonably necessary. And the purpose of those changes is explanatory notes. This clause overturns the common law principle established in A against Secretary of State 2007 and Labour authorities that's for the court to decide for itself whether there's a reasonable or sufficient prospect of removal within a reasonable period of time. The idea is that it's just for Secretary of State to decide, and it's up to her basically on what she feels like any particular day. Looking around at precedents for this, I came across this from Tanti Lam, which is a seminal case from the Privy Council detention. And said there that their lordships do not exclude the possibility that by clear words, legislature can confer power on the executive to determine its own jurisdiction. Say, for example, the power to detain is expressly made exercisable during such period as in the opinion of the director removal from Hong Kong is pending. In such a case, the court's only power will be to review the decision on Wednesbury principles. That seems to be what they're aiming for. And I wouldn't be very surprised if they took the wording from the Lamb case. This is a thing that they've had a bee in their bonnet about for a while. The people who have produced this monstrosity of an act were clearly intending to remove the court's powers to examine detention closely. The thing is, it's not the first time they've tried that. James Elliott and I did a case called Ricca-Richardson nearly 10 years ago now, where Julie Anderson got written to the Court of Appeal, arguing that essentially that was wrong. What she was saying was that the judge's approach in our case of deciding for himself, in accordance with the A case, whether detention should be on a reasonable period, had led him to apply his own subjective view instead of following the Secretary of State's objective view of whether detention had become unlawful. She got permission from Longmore, and we got there, and it was we had the Master of the Rolls at the time, and Steph was leading me in that, and he was very interested in this until I think basically Steph talked him out of it, and talked him out of it for good reason. So let's have a think about whether or not that this has actually worked. First of all, any detention power is going to be narrowly construed, and that's a long principle. Wasif Mahmood is the first time Law says it. It wasn't even Lord Justice Laws at that stage. He was just Mr. Laws, Mr. Justice Laws at that stage. And that's well-established principles. There's nothing in the Act that prevents the court making its own findings of fact. And I think in any detention case, the court will have to do that. There's no deference to the Secretary of State's factual findings in this or any other detention authority that I'm aware of. In the Fardoos case, there was very little reference to what Julie had argued. So the first place I went to look when I saw this provision was our Fardoos case. And I looked at the pleadings, but in fact, if you look at the judgment, very little of that made it in there because I think the judge decided it wasn't going to work. But in rejecting Julie's submission that the judge had taken an overly subjective approach, he talked about the judge considering all the matters for himself and said, it's the objective approach of the court which reviews the evidence available at the time and removes any question that the period of detention could be viewed as arbitrary in terms of Article 5. I think that is going to be important going forward. I still think the court has the power and the duty to make relevant findings of fact. Now, if we take that as a starting point, then look at what we saw in the case of Lamb. The point about Lamb was that it was up to the Secretary of State to decide whether removal is pending. We've already had loads of case law when removal is pending, Kadir obviously being the one that they like to refer to. But the power, what's in the legislation is that the Secretary of State may detain someone for a period that she considers is reasonable in all the circumstances. Reasonable, whether detention is reasonable, not whether removal is, for example, pending. So what if the period that the Secretary of State thinks is reasonable isn't reasonable objectively, to go back to the language of Fardoos? If the court looks at the facts and decides that the Secretary of State, that the period which the Secretary of State considers is reasonable is not in fact reasonable, and there's only one standard of rationality, we know there's loads of case law like going back for decades, it's difficult to see how that wouldn't be unlawful. It would be a breach. It would be a breach of Lumba, and of course that's consistent with what's said in Lumba about the fact that what the Hardial-Singh principles do is they ensure that the powers to detain are reasonably exercised in the Wednesbury sense. I mean, ultimately, whether you look at it through the lens of Wednesbury or Hardial-Singh, if the Secretary of State wants to detain somebody for a period that's not reasonable, that must be unlawful on pure rationality grounds. So I think that's why Lord Justice Thomas backed away from that argument when Julie was making it. And I think that's why it's now in legislation. But the question of whether they've succeeded in doing what they're trying remains to be seen, I think. There is further case law going back in respect of why a court has to consider detention for themselves. Well, the facts around detention for themselves and make that decision. But I think it's going to be very difficult for the Secretary of State to say that she changed the law in the way that she's tried to. Obviously, the big thing, the grace period, is putting in place what's already there in the case law in ACLG, subject to this, in the opinion of the Secretary of State stuff, which I think is still subject to the same flaws that I've just discussed. There is a problem with the grace period stuff anyway. Steph is a case with someone else in front of Strasbourg at the moment, which is the ASK against the ASK appeal. They've got permission. It's gone to Strasbourg, and I've done an intervention with Alex Skillick, and Amanda's done an intervention for bid, and Amanda's done one with Emma for medical justice in that. And well, the thing we're talking about is whether a grace period is compatible with Article 5. And it's strongly arguably not, I think, because it's not detention with view to deportation. I mean, in that case, it's de facto restart. This person could not be deported because he was quite severely mentally ill. There's no suggestion of that. And nevertheless, he remained in detention. The concept of grace period also runs contrary to the principle that Article 5 doesn't permit a balance to be struck between the state's interest and the individual's rights, which is exactly what's happening during the grace period, when you're just deciding where to store a person. And obviously, it's a core principle of Article 5 that detention should not endure for periods that exceed what's reasonably required for the purpose pursued. And that may be something that we're going to start talking about a little bit more. Going forward, these provisions obviously aren't going to get enforced. You can always hope that some of them won't. I mean, some of the nastier stuff from the last Labour government never made it to the statute books. And you can do all the Rwanda stuff without having to do this Hardy Singh stuff. You don't need this. One of the things I found when working on the Act was that it was just amazing nobody was talking about the fact that this applies to everybody. This is, if you compare, like what the Secretary is trying to do effectively is to give herself the power of internment without trial for all migrants who don't have leave to remain, because all of those people are in theory covered by paragraph 16 of Schedule 2. The moment you forget to renew your visa, the Secretary of State can detain you for as long as she feels like, if this legislation is interpreted the way she wants it to be. Unlike most of the rest of the legislation, it just really doesn't have anything to do with small boats at all. And for that reason, it may be that they never bother bringing this in. We'll just have to wait and see. And certainly they don't have room in the detention centres for all the people who will be affected. I think we should try to hold the line on Hardy Singh, and I think we've got a good case to do it. I think we're just going to have to try and argue that that's the way Hardy Singh essentially still means what it did before. And I think it's just going to involve really deep analysis of the nature of when to bring legality and how to interact with the power to detain, and the need to carefully examine any statement by the state that they're going to detain a person without trial, which is what's happening here. I think in terms of practically challenging things, if the court's going to give them any deference, any deference, where it's going to get it is going to be in respect to the facts, I think. So the more, if you have people in detention, you're going to try and challenge that. It'll be important to establish objective facts. I think about the possibility of removal as well, as far as possible. And then we're just going to need to make different arguments. I mean, in terms of codifying our Hardy Singh 2 and 3, I think one of the mistakes that Simon what's-his-face in writing this made is failing to fully appreciate the extent to which all of the principles are interreliant. So if you are detaining somebody and there's a clear barrier to deportation, it may be that by statute, you're not detaining a person beyond a reasonable period, but are you detaining them for the purposes of deportation, for the purposes of Hardy Singh 1? Are you detaining them with adequate diligence towards removal, with the purpose of Hardy Singh 4 in terms of reasonable diligence? And I think those are arguments that we're going to have to make. And it may be that if you'd extended the grace period, you could also say that that's not detention for the purposes of deportation, for the purposes of Hardy Singh 1, although there's some case law that's currently unhelpful on that. And it may be that now Article 5, particularly, well, depending on what happens in ASK, Article 5 may now provide more protection in Hardy Singh. We could talk about Mikolenko in terms of requirements of diligence, but also circumstances in which there is a clear barrier to removal. And it may be that we're just going to have to bring those kinds of claims now. It will mean lower damages awards, but it won't mean that people have to remain in detention, hopefully. The other thing is that I think this may increase the importance of things like the adult risk policy, which, is so unhelpfully drawn that I think it's often second or third choice as an argument in where somebody's being detained, depending on the facts, of course, but may just have more prominence now. Because as things stand, at least that's currently unaffected. So that's all I was going to say. Hopefully I wasn't short. Sorry about that. We'll have a few questions after.
Thank you very much. So, Gordon?
I'll be short. Well, yeah, I will be short. That's the good news. The bad news is that when I was preparing this bit, Greg and I divvied up sections 11, 12 and 13 of the new Act. And I realised quite quickly that Greg got the interesting bit. So that's another good reason to be quick. Basically, I'm going to talk to you about Section 11 and Section 13. Section 11 essentially provides for some new powers which interlace with the new powers and duties that Isaac mentioned. And I'm also going to talk to you about Section 13, which is the bit that, again, tries to oust the jurisdiction of the courts and the tribunal in respect of at least the first 28 days of each and every detention. I think that's, it overlaps to a certain extent with what Greg talked about in respect of where some of the battleground is likely to be in the near future, if it is implemented in the way that's threatened. Because generally speaking, despite some setbacks recently, courts don't generally like ousters, and they certainly don't like ousters where liberty of the subject is in play. So there's going to be some interesting cases surrounding that first 28 days, when, as I'll come on to, the provisions suggest that you can neither get bail nor go to court to get a judicial review of detention. So that's the interesting bit, which I'll come to at the end. Section 11 is quite technical. One of the things it does, what I'll just mention, what I won't go into any detail about, is it does amend Section 62 of the Nationality and Immigration and Asylum Act, which gives the power to the Secretary of State to detain somebody of any age in any place that they see fit. So that's quite a big change, and it does widen the scope of the sorts of institutions and buildings that people can be detained in. It also amends Schedule 2 to the 71 Act and Section 147 of the Immigration and Asylum Act. And as I'll come on to, it lays the groundwork, or at least lays the foundation for routine detention of unaccompanied minors. And you'll see what I mean by that in due course. Oops, sorry, my technical know-how has let me down straight away. No, back on you. Sorry, I don't know what I did there. We're back on Greg's. Okay. Thank you. Just that button there. Thank you. All right. So section 11.2 of the new Act. What that does, it inserts a new section 2C into the old Act, 1971 Act, and paragraph 16 of Schedule 2. So it does essentially four things, or creates four powers. The first one is a power to detain somebody where an immigration officer suspects that they may meet the four conditions that Isaac talked about. So the coming to the UK after the commencement date, not coming directly from the country at which they were risk, etc., etc. So we know that that is a power of suspicion. So all that's necessary to invoke that power is the immigration officer suspects that they meet those four conditions. Second power is if the immigration suspects that the Secretary of State has a duty to make arrangements for their removal under Section 2. So clearly there's quite a significant overlap between those two powers, but they're both powers of suspicion. And then once that duty has been established, there's a power to detain pending removal from the UK, very similar to the power in Schedule 2 already. And finally, and this is where there be monsters, the fourth power is if the four conditions are met, but there is no duty to remove by virtue of section 4.1. And section 4.1 is, as Isaac mentioned, is the disapplication of the duty to unaccompanied minors. So there is a power under sub-paragraph 2C to paragraph 16, schedule 2 now, potentially, to detain unaccompanied minors under that provision. So that power is in play where there are four conditions. So firstly, and it's any of these, pending decision to give limited leave to enter or remain, pending decision to give leave under section 8AA of the 71 Act, so that's discretionary leave where don't fall within any of the other provisions. 3, pending a decision to give leave under section 65(2) as a victim of trafficking. And 4, this is the catch-all decision under 4.2 of the new Act, pending removal of an unaccompanied minor on one of the various provisions that Isaac talked about. So you can see that the interplay of those two sections is quite a significant amount of framework for the routine detention of unaccompanied minors. And when I come on to section 13, there's also specific provisions about that there. There was, and Greg will know more about this than I do, but there was in the bill certain provisions to disapply the existing limitations on the detention of pregnant women. That has not made it through to the Act itself. Sections 2D and 2G of paragraph 2 retain those limitations in terms of the length of detention. So it remains the case that a pregnant woman can't be detained for longer than 72 hours unless it's authorised by a minister, and even in those cases, they can't be detained for longer than 7 days. I was trying to work out the relationship between the new Act and the old Acts in terms of amendments to the various powers to detain pregnant women. The old section 60, I think, of the 2016 Act limits it to two scenarios. One is where removal is essentially imminent, or 2, exceptional circumstances. And it seems to me that that scope is widened by this Act to allow detention pretty much in the same terms as I've set out there, where the conditions are met. So whilst the length of detention is still protected, the reasons and scope for that detention in the first place seems to me have been widened. Okay, so section 2H brings in the power for the Secretary of State to make regulations about the detention of unaccompanied children. And it allows the Secretary of State to make regulations specifying time limits for the detention. Interestingly and somewhat worryingly, it permits making regulations to confer a discretion on immigration officers re the detention of unaccompanied minors. And the new section 2K gives the power to the Secretary of State to make regulations, to make different provisions for different purposes, which is about as wide a power to make regulations as it is possible to make. The regulations must be made by a statutory instrument are subject to the negative resolution procedure, but nonetheless, that's a very wide power to make what is anticipated to be regulations governing the detention of unaccompanied minors. As I mentioned, Section 11 also amends Section 62 with regard to places where detainees of any age can be detained. And it also removes the time limit in the Immigration and Asylum Act 1999 for detention in pre-departure accommodation. So the only tiny bit of good news in the entire section is the nastier bits of the powers to detain pregnant women didn't make it through from the bill to the Act. Okay, so section 13. Now, I think the thing to say about section 13 is that it's really quite difficult to predict how this is going to pan out in practice, because on its face, it has two aspects and two powers. Firstly, it prevents the first tier tribunal from granting bail until 28 days after detention has begun under this Act. And it also provides that you can't challenge detention in the courts during that period. So you can't bring a traditional application for judicial review or High Court bail or High Court interim relief during that first 28 days. Apart from a couple of very narrowly drafted exceptions. So you can, if you can show that the Secretary of State or the immigration officer has acted in bad faith, or in such a procedurally defective way as amounts to a fundamental breach of the principles of natural justice. The other saving principle is that habeas corpus is retained. So where there is, in the same way that Greg touched on in his section, where I think the legally interesting part of this power is going to be the definition of both bad faith and procedurally defective in the context of detention. Because one thing we do know is that the courts are quite keen to, I think the phrase they use is jealously guard their role as protection of liberty, particularly in cases, immigration cases, where somebody isn't serving a custodial sentence. So in this case, I think at least what sprung to my mind was that one would be attempting to argue that procedurally defective covers a whole host of different errors, mistakes, unreasonable views, leaving out of account classic public law errors, leaving out of account of evidence, failing to take into account evidence, to take into account of irrelevant material. Some of that might be quite ambitious, I think, but definitely worth the argument, at least in the early stages. Obviously, the Secretary of State will be arguing that procedurally defective means the sorts of things that it was said to mean in O Ceallaigh, which is very narrow. But I think in cases where you have protection of liberty and another factor, such as someone who's significantly ill, vulnerable, meets the adults at risk policy, all of those factors, I think, would lead a judge to listen very carefully to arguments about the scope for arguing that the ouster clause doesn't count even in that first 28 days. There is provision within section 13 that in certain circumstances lowers that time limit to 8 days for unaccompanied minors. But that, of course, is the period at which bail can be granted. It's not automatic, it's the period that bail can be granted. And just last part of that slide, decisions explicitly include purported decisions, and that's because there's case law in previously interpreted ouster clauses where the courts have said, well, you said we can't consider a challenge to a decision. This decision is so bad that it doesn't amount to a decision. So they've covered that off by saying even purported decisions count. So if we call it a decision, even if it's a terrible decision, it's still a decision. So they have drafted it with, as Isaac mentioned, the case law in mind. Okay, so again, I've covered this. It's the three areas of challenge I think one needs to be sort of alive to is the general scope of challenging ouster clauses, because they are there is a long line of authority. O Ceallaigh is the latest, as I think you both mentioned, both Greg and Isaac mentioned. O Ceallaigh was the case about whether Carte JR ouster was lawful or not. it's quite a limited judgment, actually, if one reads it, in terms of what was argued before the judge, and indeed the amount to which he grapples with some of the underlying arguments. So there's obviously essentially a first instance decision. So there's some scope, I think, to have another go at that. Obviously, his decision will not be binding on another High Court judge. The interpretation of procedure defective, as I've already said, I think is potentially fruitful. And lastly, where you have, and Greg mentioned this, Article 5, May finding habits day in the sun, it's historically been not that useful. Occasionally it comes into play, but not that useful in general detention challenges. It may be in a case where one can point to detention within 28 days as being arbitrary in some way. It may come in useful there. And indeed, where someone is profoundly ill, and we know that healthcare in detention centres is not good, and is only likely to get worse as numbers increase and other detention options are explored by the government. So where someone is profoundly vulnerable or ill, I think it would be very interesting, it would be very challenging for the Secretary of State and the court to argue that an Article 3 challenge couldn't be brought within 28 days. I think that just can't see that being held up. So those are the three things that come to mind. I suspect there are lots more. I think I have been reasonably short, so get some credit for that, if nothing else. Thanks very much.
So we're going to start again with Georgie, dealing with children.
Yes, so I'm dealing with unaccompanied children and going through changes to age assessments and then kind of linking that back to how it's relevant to some of the provisions on detention that everyone's covered. So first, I'm broadly going to look at what age assessments are and how the process worked before the legislative changes over the last year. And then we're going to go back a year and look at what the Nationality and Borders Act changed. And that will set the scene for the reforms to age assessments that have come in under the Illegal Migration Act. So the Illegal Migration Act, well, firstly, it reverses the previous commitment under the Immigration Act 2014 to end child detention. And secondly, it limits protections that were still available to children following the Nationality and Borders Act. And now those protections will only apply to what is now called unaccompanied children, and they're newly defined in Section 4 of the Illegal Migration Act. And that's different from the previous definition that we knew from the immigration rules of an unaccompanied asylum-seeking child. So Gordon's already given us a summary of Section 11 and 13, and that's ousting the jurisdiction of the courts in the first 28 days to grant bail. But under Section 11, under Section 13, there is an exception so that unaccompanied children can be granted bail after 8 days in those limited circumstances that he outlined in Schedule 2C, D, 1 to 4. So on the 5th of July this year, the government published a children's rights impact assessment, and they found in that taken in the totality, including the overriding interest to protect children from trafficking, the Act should have a positive impact. But the Children's Commissioner responded that they were far from convinced that that's the case, and indeed they were concerned that the threat of child deportation will be a gift to traffickers, as children will feel less able to seek help from professionals and instead will go missing at the hands of their exploiters. So next, going on to the fundamentals of age assessments and the procedure as it was. So common situation is that a putative child is assessed to be an adult and by the Home Office on entry, but then the LA would need to do their own assessment. So the local authority would need to do their own assessment when they presented themselves to children's services. And it was important that we had this second line of assessment because it meant that the children could benefit from protection under the Immigration Act 2014. And establishing that you're a child as a precedent fact is, of course, vital to securing support under the Children Act, especially Section 20 and the accommodation that follows. And once you're in Section 20 accommodation, of course, you can then thereafter become an eligible child and continue to benefit from local authority support once you reach majority. But now, establishing that you're a child as a precedent fact is more important than ever. As Isaac said, the duty to remove doesn't apply to children. And there's obviously still a power to remove children. But you'll want to establish from the offset that the duty in Section 1, Section 2 does not apply. So yeah, age, previously age is an objective fact which admits only one answer, and age assessment judicial reviews aren't like normal judicial reviews. There's much lower threshold, and you don't need to show those conventional public law errors because the court will exercise its own jurisdiction to find the age of the child. I'm sure we'll all be familiar with Merton, which is the kind of gold standard of what needs to be put in place procedurally in order for an age assessment to be fair. So some of the conditions include having 2 qualified and experienced social workers, an appropriate adult where needed, and they need to undertake a comprehensive and holistic assessment. And the young person needs to be given the opportunity to clarify and rebut any matters that are held against them. And importantly, they should receive the benefit of the doubt. Also, the local authority needed to give reasons, and that was the main basis for challenges to age assessments. If the reasons were inadequate, you had a pretty surefire challenge there. And the guidance in the Association of Directors and Children's Services document was, although it wasn't binding, the statutory guidance was, and the age assessment guidance would be relevant to any considerations of whether a local authority had cogent reasons for departing from the guidance. So in that guidance, for example, there is the presumption that a child should be treated as a child until proven to be an adult. It's clear that age and demeanour are notoriously unreliable indicators of age, and there was often challenges to age assessments that were based on those factors alone. However, case law has developed, and we've got the case of Han and London Borough of Brent decided last year, and that kind of reset what was required for a fair process in age assessments before we even get onto the legislative reforms. So Judge Swift decided that what would be fair depended on the circumstances of the case. So there's not a tick list. It's not that you need an appropriate adult in your age assessment. It's what the facts of the case require. And he also decided, importantly, that the distinction between short form age assessments and full Merton compliant age assessments are legally irrelevant, which obviously opened up the door for more of these obvious cases where local authorities, social workers could base a decision very quickly on someone's age and demeanour. So that's kind of where we were with the case law. And now we're going to move on to the Nationality and Borders Act. So under Section 49, this seems to reverse the position of a person being a putative minor. So that's a child until proven an adult. So it defines an age-disputed person as an individual who requires leave to enter the UK through a local authority, public authority, or the Secretary of State, has insufficient information to be sure of their age. So if there's any question mark over their age. And then there are designated people, and they will be designated by the Secretary of State to conduct the age assessments. So they won't be done by the Home Office or the local authority anymore. They're now done by the National Age Assessment Board, which is a newly constituted board. And we'll look at that in more detail in a moment. But it's clear that the new procedures will apply to all people who require leave, so that's not just asylum-seeking children. And there's no clarification in the Act of what sure means in this context. So is it that they're unsure of the exact age of the person, or is it unsure if they're an adult or a child? So there's much broader scope for someone to be an age-disputed person and therefore fall foul of needing to follow the procedures thereafter. So Section 50 of the Nationality and Borders Act defines the new process for age assessment. So an age assessment will take place where a local authority needs to know the age of an age-disputed person. So that would obviously be for Section 20 accommodation or other local authority child support. Or the Secretary of State notifies the local authority that it has doubts as to the age of an age-disputed person that the local authority has exercised functions under. So the local authority might have accepted this person to be a child, they're in Section 20 accommodation, and the Home Office will raise a dispute, and then that child will now have to come before the National Age Assessment Board and be assessed and deprived of those local authority services. And the Secretary of State will conduct the age assessment themselves. And this is important when we look at the Secretary of State's new powers under the Illegal Migration Act. That means the Secretary of State can now house children. So when the designated person, so that's the board, conducts the age assessment on behalf of the Secretary of State, the outcome is binding on the local authority, but it's not binding on the Secretary of State. So, and if the local authority conducts an age assessment, it must provide evidence, and then the local authority's own assessment is different. The local authority has to provide evidence to the Secretary of State so that the Secretary of State can consider the decision. So local authority has had this child for however long, people like social workers have interacted with the child for however long, and they have serious doubts that this person is actually an adult, as the Home Office is saying they are. But the Home Office doesn't have to take that into account or conduct a new assessment. They just have to consider the decision, and it's unclear what level of consideration that would be. The British Association of Social Workers said as well that they have grave concerns over the institutional pressures on the social workers that are working in the National Age Assessment Board, because obviously they won't be independent and they will be subjected to meet immigration-related targets, and this might cloud their judgment in a way that we would hope doesn't happen in the local authority context. So this is another section that is now in force. So Section 51 applies when the Secretary of State needs to make a decision about immigration functions, and they can undertake this kind of assessment when Section 50 is not relevant, but it's unclear when you wouldn't need a Section 50 assessment if, as soon as somebody is an age-disputed person, that's the procedure that takes place. But this is a separate procedure, and it will be binding on the Secretary of State purely for immigration functions. This is probably the most contentious part of the Nationality and Borders Act before it was amended by the Immigration Act in terms of age assessments. So this came into this part of the Act came into force on the 28th of April, but the regulations haven't been made under it yet. But it permits the Secretary of State to make regulations specifying scientific methods that may be used to determine a person's age, even though these methods have previously been discredited as harmful and unreliable. It provides a list of what these methods may constitute, such as DNA analysis, saliva and other samples. And the Secretary of State has to seek advice before making the regulations. So, of course, the regulations themselves would be challengeable by way of judicial review as secondary legislation. But it's clear from the evidence of the offset that this is a notoriously harmful and unreliable form of testing someone's age. And then we get on to the consent. So scientific methods may only be used with appropriate consent, but Section 55(7) of the Nationality and Borders Act provides that in deciding whether to believe that an age-disputed person in their credibility, the decision not to consent to the use of scientific methods will be relevant in damaging the credibility of that claim. And that's been amended even further by the Legal Migration Act at Section 56, which we'll move on to now. I've just included this in the slides for whenever those regulations come in. But the Interim Age Estimation Scientific Advisory Committee produced an interim report in October, and it highlighted some recommendations and concerns, but one of them, we can see recommendation 5, was that the use of ionising radiation must be limited because it can be damaging to children's bodies, but that is one of the methods that is currently being considered. So here are some provisions of the Nationality and Borders Act that aren't yet in force. And it seems that the reason they aren't yet in force is because they've been amended and made even more draconian by some of the provisions in the Illegal Migration Act. So Section 54 and 55 relates to appeals of age assessment decisions, and it creates a statutory right of appeal to the first tier tribunal. So there's a move away from judicial review to appeal rights, and that might be a good thing because you, at first blush, you've got a substantive appeal. But the judicial review threshold in age assessments is already low, so it's not actually that much of an advantage. It's going to be heard in the asylum, the Immigration Asylum Tribunal, whereas it should probably be in the Health, Education and Social Care Tribunal, where there are 2 expert panel members that could properly comment on a person's age. And also because it's in the first tier tribunal now, the fee structure will cause problems in terms of access to justice, because at the moment, obviously you can bring it as a judicial review and then you've got the possibility of claiming inter partes costs, but it will be less sustainable if it's under the first tier tribunal fee structure. But all in all, the Nationality and Borders Act felt like a gatekeeping exercise to stop someone establishing that they're a child as a matter of precedent fact, and creating difficulties in holding decision makers to account. But now we have the Illegal Migration Act, which is a level up. So Isaac's already taken us through the duty in Section 2, and that's must make arrangements for the removal of a person meeting the following 4 conditions. And that duty does not apply in the case of unaccompanied children. But the definition of an unaccompanied child, as I mentioned earlier, is threefold. It's that the person meets the 4 conditions in Section 2, that they're under 18, and at the relevant time, no individual who was, don't know how I managed that, no individual had, who was over 18 had care of the child. So the definition of an unaccompanied asylum-seeking child in the immigration rules at 352 ZD was broader, and it included children who had lodged their claims when they were under 18. So the age was set at the point in time of entry. And so, for example, if someone was separated from both their parents and not being cared for by an adult in law or by custom had responsibility to do so, they fell under the definition of a UASC. But in the new definition, if the person is being cared for by anyone, an extended family member, for example, or if someone came over with them and they made friends, that person might just be, well, you're an individual who is over 18 and had some care of C. So that's very different to before. It needed to be a parent or someone who was required by law to care for this person. So yeah, it takes a lot of potential unaccompanied children out of the scope of the exception in section 4, which means that, of course, they will fall foul of the duty in section 2. So then, in terms of changes to the age assessment process, section 57 sets out the changes in detail, including removal of appeal right to the decisions, and it allows removal of a person while judicial review challenge is ongoing. Courts and tribunals are told that they may only decide the decision was wrong in law and not that it was wrong as a matter of fact. And section 58 threatens regulations to set out consequences of people withholding consent for the scientific testing, which may include treating the person as though they are over 18 by default if they refuse consent. Neither of these two provisions are yet in force, and it seems like the Home Office is holding off until the conclusion of the Rwanda litigation. But we will have to watch this space to see where that goes. So crucially in section 57, subsection 4, the application, so to appeal under section 51 or 50 or 51 of the Nationality and Borders Act, does not prevent the exercise of any power or duty under this act to make arrangements for the person's removal from the UK. So even if you've got an outstanding age assessment appeal, you can still be removed during that time. And at subsection 5 there, we've got the ouster clause on the tribunal no longer having being able to decide that the decision was wrong in fact, but only that it was wrong in law. So we're whittled down to our public law challenges again there. Section 58, the scientific methods. The regulation may provide, in the circumstances set out, that the person is to be treated as if the decision maker had decided that they were over 18 if they refuse consent to the scientific methods. So we'll have to see first what the regulations are, but of course this provision will need to come into force, which it hasn't yet done. I just whacked this on the end because when we were looking at the detention of unaccompanied children, the Home Office now has the power to arrange for the provision of support for children. So they will be the corporate parent in the place of where normally it would be the local authority. And when a local authority notifies the Home Office, so we saw under the Nationality and Borders Act that a local authority must now notify if they have doubts about the Home Office's own assessment of age. That kind of puts the Home Office on notice. So under section 17, the Home Office can say to a local authority who's housing a child, even if the local authority says, we have doubts, we think you're wrong, this person is almost definitely a child, the Home Office can immediately transfer them out of local authority accommodation into Home Office accommodation, which makes it one step easier to then put them in detention as soon as they're able to do that. It's not good. And I hope that was helpful, even if the act isn't. Thank you.
That was brilliant getting through all of that. So. I'm just going to talk about a couple of things. And then Emma is going to deal with trafficking. It looks like Gemma's not going to be able to make it. She's stuck on the way from Birmingham. But primarily what I want to talk about is just a few observations about human rights and protection claims and judicial review claims, and the way in which they might be presented and formulated, so as to avoid, first of all, the possible consequences of a claim being declared inadmissible, which is the fate of various human rights and protection claims. And secondly, to try to sidestep the prohibition on the court or the tribunal granting interim relief if it delays removal. I mean, as to whether the suggestions have got any long-term merit is another question, but it just occurs to me as a possible means of dealing with them. I mean, I think it's the inadmissibility issue, I think, is important, even if the Section 2 removal duty does not fully come into effect, because it does have the potential to leave, even if people are not removable, it does have the potential to leave people in protracted indefinite limbo if their claims are forever to be treated as inadmissible. So the first thing I think to remember, and it's not necessarily easy to remember when reading the Act, is that the Act does not disapply Section 6 of the Human Rights Act, which is the provision that makes it unlawful to act in breach of a convention right. I mean, it does expressly disapply Section 3, but the fact it expressly disapplies Section 3 highlights the fact that other provisions of the Human Rights Act, specifically Section 6, remain in force. So that, I think, is important. It's also, I'd say, important to note the nature of the duty to make arrangements for a person's removal, because obviously the nature of that duty is something which the court will be weighing in mind, being Parliament has imposed this duty. Is what you are proposing or saying incompatible with that duty? So important to bear in mind the precise nature of that duty to see what it is that you are up against. And I think it's important to remember that it's not a duty to remove a person as soon as reasonably practicable. It's a duty to make arrangements for the person's removal as soon as reasonably practicable. And I do think that that is of potential importance, and one might be able to say that reasonable practicability of removal requires satisfaction that the decision to remove is itself lawful, and so that arrangements for removing the person should incorporate a necessary period of time for determining the lawfulness of removal. So that's a point about the duty. Then, as far as inadmissibility of protection and human rights claims is concerned, first of all, the Act does not tell us very much about the consequences of a claim being declared inadmissible. It does not say, for example, that the claim will not be determined or that the Secretary of State may not determine the claim. The only specific thing that it tells us about the consequences of a claim being declared inadmissible is that the claim will not be considered under the immigration rules. But we also know that claims of this nature have historically been and frequently still are considered outside the immigration rules. So it's not obviously a bar to the consideration of a claim, it's simply a bar to the consideration of the claim under the rules. And again, bearing in mind that the court can be expected to take a very strict approach to construing statutory provisions that potentially have such grave consequences for the people subject to them, I think the court is potentially open to persuasion that an inadmissible claim is nevertheless one that must be considered. But there's also, I think, a very important provision in the Act, or introduced by the Act, which makes it quite clear that protection and human rights claims and other kinds of claims, even if declared inadmissible, must be considered by the Secretary of State. And that's Section 30 of the Act, which is now in force. And what Section 30 does is it introduces a Section 8AA into the 1971 Immigration Act. So as I say, that provision is in force, although it's in force in a modified way until and unless Section 2 comes into effect. So much about Section 8AA is extremely unwelcome. It applies to a person who meets the four requirements for removal under Section 2, although it takes the date back to, is it the 7th of March? Yeah, so anyone who meets those conditions from on or after the 7th of March is liable to be, Section 8AA applies to that person. And what Section 8AA does presently is that it prevents a grant of indefinite leave to remain to a person who meets or has ever met those 4 conditions. So the most such a person now can get is a grant of limited leave to remain. Unless that is, it would be a breach of the person's human rights to be refused indefinite leave to remain. In those circumstances, ILR may be granted, but otherwise not. But what I think is very important about Section 8AA, as it will operate if and when Section 2 and all of those provisions come into force, is that although the Act seems to be about steamrolling people into removal from the UK without consideration of their claims, subsection 4 of Section 8AA says that the Secretary of State may give leave to remain to a person if she considers that failure to do so would contravene the UK's obligations under the Human Rights Convention or any other international agreement to which the UK is a party. So that is, it would seem that the whole array of international obligations that potentially require a grant of leave to remain have to be considered by the Secretary of State and should result in a grant of leave if the person qualifies. So that would obviously be the Refugee Convention and the Convention Against Trafficking and the provisions in that may require a grant of leave in far broader circumstances than this Act would seem to allow. So whatever ultimately the effect of a claim being declared inadmissible is, it would seem that Section 8AA still obliges the Secretary of State to grant leave to remain if the person falls within one of these international agreements. And that, I think, also makes me think that the way to present claims to the Secretary of State is primarily by reference to a claimed entitlement to leave to remain. So I think it may well be advisable that if you meet somebody in detention and you're trying to make representations for that person, what you would be wanting to say is that I am entitled to leave to remain because I have got a right under the ECHR or the Refugee Convention or ECAT to be permitted to stay in the United Kingdom. And that is a claim of a kind which cannot be categorised as inadmissible because the statute is quite specific about how it defines claims. I mean, in terms of human rights claims, it imports the Section 113 definition from the 2002 Act, which is that removal of the person would be a breach of the person's human rights. Well, if you make a claim that the refusal to give me leave to remain would be a breach of my human rights, that is not a human rights claim of the kind which the Act allows to be treated as inadmissible. It's something completely different. And similarly with protection claims. I mean, protection claims in this new Act are defined by reference to Section 82(2) of the 2002 Act. So a protection claim under that definition is a claim that removal of the person would be in breach of the UK's obligations under the Refugee Convention or the UK's obligations to a person entitled to humanitarian protection. So that is the kind of claim which is inadmissible. But there are other kinds of claims that a refugee might make. A refugee may say, well, it would be a breach of my right under the Refugee Convention to be able to work, to refuse me leave to remain. Similarly, a breach of my right to welfare provision of the kind that is generally available to refuse me leave to remain. There's a whole array of positive obligations under the Refugee Convention, not just the Article 33 prohibition on refoulement. So if a claim is articulated by reference to those positive obligations, then it does not fall within the kind of claim that can be declared inadmissible. And I think that So I would suggest thinking about presenting claims in that way to avoid the inadmissibility provisions and the various consequences of those. But I'd also suggest advancing a claim in those ways to try to sidestep Section 54 prohibition on the court granting interim relief. Because, one thing that we can rely on is that the court will have to construe a purported outer clause extremely strictly, particularly when the attempt to oust that part of the court's jurisdiction will have such grave consequences for the individual concerned. It must be construed very, very strictly, very narrowly. So Section 54 applies to any court proceedings relating to a decision to remove a person from the United Kingdom. So it's in proceedings where the challenge is to a decision to remove the person that the court is not able to give interim relief that impedes removal. So I would argue that if you bring a challenge to a decision to refuse leave to remain, where leave to remain has been sought on human rights grounds or ECAT grounds or refugee convention grounds, the proceedings that you would bring in relation to that decision would not be proceedings relating to a decision to remove a person from the UK. They'd be proceedings relating to a decision refusing to grant leave to remain to the person. And that is not a kind of proceedings to which the prohibition on granting interim relief applies. So, hopefully that would be a potential argument for avoiding Section 54. Just another couple of words about a human rights claim, which is not a claim about removal from the UK. One would have to think of a way of formulating the claim, which is not saying my removal to Albania will result in me being tortured or killed or whatever. It would have to be a claim about my private or family life in the UK. And so there does not need to be any reference to removal from the UK or the nature of the destination. It's a situation, I'd say, where there's often discussion about whether the positive or negative obligation under Article 8, for example, is in play, and it's usually said that it doesn't really make a lot of difference. But I think in this context, it possibly does. If you're able to assert a positive obligation that you be given leave to remain, then it removes the focus from removal and enables a judicial review challenge to be brought by reference to the refusal of leave to remain. Sorry about that. I'm not really going to say anything much about Albania because running out of time. But I think the slides which David Neal has written are going to be circulated. And I think the most useful thing about any useful thing about those slides is that they make reference to very, very good material that shows that the Home Office position set out in the CPINs that asylum claims by Albanians are hopeless, that position is not tenable if one actually looks at the material upon which the CPIN is purportedly based. So there's a very, very good analysis by David and links to material to support that analysis, which would enable it to be said that the Albanian protection claim is exceptional. I would say that the argument should be that exceptional means, in the context of Albanian claims, a claim which has got potential legs, which may succeed. Because the Home Office think the rule is that they are untenable. And I don't think that ZV, although in the slides he cites that ZV Lithuania case, I think it probably has very limited application to Albanians, given that Albania is not part of the EU. So anyway, I'm going to hand over to Emma, in the absence of Gemma.
I should say that this was very much a joint presentation between Gemma and myself. And unfortunately, she's been detained at court. So if you do have any particular questions or queries, she says she's more than happy to speak to everybody one-on-one. So In this graveyard slot, I'm going to cover the modern slavery and trafficking provisions. And basically, I think the first thing that's worth flagging is that the government accepts head on that it's a direct conflict between ECAT and this Act. And you'll see that I've given a link here to one of their policy papers that they published while the bill was going through Parliament. And importantly, what they say is the justification for this application of many of the protections for victims of trafficking is that the small boats crisis in and of itself is a public order threat. And you'll see there the second paragraph. So this is what the government is invoking to say that it can disapply protections under ECAT. And as we'll come on to look at, that's very much contrary to what ECAT is based on, and it's a deliberate misinterpretation of the public order exception. So with that in mind, if we look then, the first issue is really about removal, which Isaac has obviously very thoroughly explained in terms of the general criteria. How that affects trafficking victims is in the following way. If you've got a person now with a positive reasonable grounds decision who meets the 4 removal criteria in section 2, then they will no longer be legally protected from removal. And that's because section 22 of this Act will disapply the statutory protection under the NAB Act to prevent their removal. And it also disapplies any obligation on the Secretary of State to give them temporary leave under section 65. And so the immediate problem you can see if you've been working with victims of trafficking, modern slavery, is that many people will fall within the section 2 criteria precisely because they've been trafficked to the UK. So a person who's been trafficked is not going to have entry clearance. They may well have entered in breach of a deport because they may have fallen back into the hands of smugglers or organised criminals. But the Act makes no distinction for that. And obviously you've got 2 particular international guarantees that are relevant here. You've got under ECAT, general principle of non-punishment, and that provides that states should provide within their legal systems the notion that trafficking victims shouldn't be punished for criminal acts. But the Special Rapporteur's interpretation is that that also extends to deportation, so arguably we should be saying it should cover removal in these circumstances. And you also have the Article 31 Refugee Convention point on penalty, which Isaac talked about as well. And ultimately, I think this possibly raises an interesting question in terms of the UK's reputational position globally, because it's currently a Tier 1 state for the purposes of the US State Department, which means it's among a few states that are seen to meet anti-trafficking norms. However, even within the most recent report, the US State Department's position is that one of the prioritised recommendations is that the UK should ensure victims are not inappropriately penalised solely for unlawful acts, including immigration violations. That's on the basis of existing practice, and that's only going to get worse if this Act, in fact, is brought into force. You've got to, I think, politically think about the cases to be made, particularly with perhaps some of the members of the Conservative Party who have been more advocates for trafficking than perhaps the current office holder. This is going to do real damage in terms of the UK's credibility in protecting victims of trafficking, and also in being a voice to combat and hold to account other states that are also less compliant with their obligations. So if we look then at how this removal carve-out is going to practice. So I just explained that generally if you've got positive RG and you meet the 4 criteria, you will be removed unless you can bring yourself within the very narrow carve-out that's provided for at subsection 3. And you can see there, I've put the text on the slide, that essentially this is an exception only for individuals who are participating in an investigation with a public authority. But that in of itself is not sufficient. It's quite narrowly drawn. You'll see that it's not just that you're cooperating with the police or you're having an investigation with the Home Office, it's that the Secretary of State needs to be satisfied that it's necessary for you to be present in the UK to provide that cooperation, and also it imports a balancing exercise that the Secretary of State needs to consider the public interest in person providing that cooperation is outweighed by any significant risk of serious harm to members of the public. Now, this seems like overkill, right? Because these people are very often victims who will be affected by this. So you've got to ask on the individual assessment, what is the actual public harm that your 19-year-old positive reasonable grounds case poses to the public? So I think that, I've spoken to Gemma about this, about ethically, whether as practitioners, we need to be flagging to clients. One of the ways you could potentially challenge your removal is if you are in a position to cooperate with the authorities. On the other hand, we know from our practice, many people are not at that position yet because very often they've just escaped from the clutches of the traffickers. They haven't had access to any recovery services. We may not even know the full account. They may only be telling the very, very beginnings of the account. But it's something to perhaps be mindful about as something that is potentially available as one of the ways of defeating removal. And it's just worth noting as well, what amounts to compelling isn't defined in the statute. It's going to be subject to guidance, and that's provided for subsections 5 and 6. More bad news, unfortunately. In addition to that, there's also an express statutory exclusion from access to support. So the provision for England is in section 23, similar provisions made for Northern Ireland and Scotland, sections 24 and 25. But essentially what section 23 will do is it will disapply the duty under the Modern Slavery Act at section 50A to provide necessary support and assistance.
And is that also retrospective people that have already had reasonable grounds decisions?
This is for people who fit within the 4 removal criteria. So it would be people who have arrived within from March 2023, I think, or perhaps June, is it? July 2023. In addition, what the Act also does is it will expand the disqualification from protection, so that the PODS litigation has already been ongoing. So under the NAB Act, the threshold was automatic deportation for a national criminal, sentences of 12 months and above, as well as other categories. But for our categories of client, I think that was the most relevant one. That's now been relaxed, and it's going to mean that the Secretary of State has a wider, well, she will be obliged to disqualify, but also under section 29(4), it's any conviction for a term of imprisonment. So anybody that is conducive deport, so 12 months less now, also falls within the public order disqualification. In addition to that, I think it's also just worth flagging in the interpretive provisions, Jim and I had a quick look at yesterday, is that suspended sentences are not counted within that. So if you've got a suspended sentence only, you wouldn't be subject to public order disqualification. But a person who was sentenced to detention, including mental health detention, or a person who was sentenced as a youth offender to detention in a young offenders institution would be caught by that. So very harsh threshold in terms of basically anybody that's had any kind of contact now with the criminal justice system, bar a suspended sentence order or a fine, is going to be liable to these public order disqualifications. So it's really reduced the threshold in terms of who's not going to be identified beyond a reasonable grounds decision, who's going to be denied a recovery and reflection period, and who's also going to be denied ultimately a residence permit. And then there's just finally just to flag that at section 96(6), the disqualification provisions apply irrespective of whether a person has received a positive RG or conclusive decision, including if before the Act came into force. So in terms of the legality, obviously, I think a number of the speakers today have flagged that as the bill was going through the House of Commons, it hasn't been possible to certify that it's compatible with the ECHR because it's not. And also there's an express reference, as Ronan has explained, that the courts are not allowed to read down this statute under section 3. So what we're left with in our toolkit is section 4, declaration of incompatibility, and also section 6, the duty on the Secretary of State to have compatibility with these. And the real crux of the problem in terms of what this Act does for victims of trafficking is it disqualifies them from protection on a broad basis based on their mode of arrival. which raises numerous issues in terms of both ECHR and ECAT. And the government's view in their ECHR memorandum is that they conclude that radical solutions are required to put a stop to the small boats crossing this channel. It's therefore new and ambitious, but taking such an approach means the Home Secretary is unable to make a statement under Section 19. So if we look at then ECAT perhaps in a little detail, just in terms of the kinds of challenges and issues that are thrown up. There's two articles I just wanted to focus on today for today's purposes. Obviously, the first problem is removal. So Article 10 of ECAT prohibits the removal of a reasonable grounds victim of trafficking until the investigation has concluded. That's not qualified in ECAT, but the Secretary of State has misread the convention to say that because of the public order crisis of the small boats, she is entitled to disapply the standstill provision of Article 10. And you'll see from the reference there to the Greta explanatory report to the convention, it's very clear that that's how the convention should be interpreted. And that's also what matches the Article 4 case law. So Article 4 ECHR, it's non-derogable, it's an absolute positive obligation, and it's not qualified. So you shouldn't be able to prevent a reasonable grounds victim proceeding to a conclusive grounds stage. You may have a case for saying, for reasons of public order, they are not entitled to a residence permit. That is different. That's about the consequences of identification. It's not about the primary question of whether or not they're a victim in the first place. And the other point to raise about this is the carve out on suspending removal in the event that you were to cooperate with an investigation and the Secretary of State accepts that you need to be here to do so. And that also contradicts the approach that's set out in ECAT. ECAT very much recognises that victims will need time to facilitate their participation in investigations. And that's also reflected in the explanatory report. The other article to just flag, I think, importantly here is Article 13, which is the recovery and reflection period, which provides that states have to legislate for a minimum 30-day period. This does include a public order exclusion, but the problem is that the Secretary of State has interpreted that in a very broad way to catch every potential victim of trafficking. And it's clear from the explanatory report that the experts, Greta, think that it's supposed to apply to everybody who's illegally present. So that would be everybody who comes within Section 2 in any event. So you can see that there's a clear misreading that I would say has been done in bad faith of what the convention actually means when it says you can withhold a recovery period for a victim of trafficking. And then in addition to that, the other real issue is the problems with the ECHR compliance. So obviously Article 4 places a number of positive obligations on states, and our own courts recognise that a real problem for victims of trafficking is that a person who's trafficked is very likely to be re-trafficked in the future, but also, and this comes from Ronan Toal, they're not likely to have been able to escape the clutches of their traffickers at the point where there's credible suspicion. And all of this cohort are in that category because it's the very early reasonable grounds stage. So you can already see that there are going to be potential breaches of obligation to identify because they're not going to have their conclusive grounds decision. There's going to be breaches of obligations to protect because either you're going to send them to Albania or Rwanda where they may well be re-trafficked, or you're sending them to a place where they won't be able to access the recovery services that reduce risk of being vulnerable to exploitation as well. And then finally, there's going to be breaches of investigation because nobody's going to even get to the conclusive ground stage, which means how will the UK authorities actually ever determine what happened to the person and the possibility of penalising the traffickers. But also even the carve out for investigatory cooperation is so narrowly drawn and so dependent on the Secretary of State's view of the case that it's probably going to exclude lots of people who aren't ready to cooperate yet because they're just not at that stage.
The police even investigating.
Exactly. Most of the time police say there's nothing for us to investigate because this happened overseas in an event. And this is something I also thought about, was specifically when looking at that investigatory carve-out, is that many of the victims of trafficking will also have a disability for the purposes of the Equality Act, because they will have a medical condition, often a psychiatric condition, which will impair their day-to-day ability. For many of them, that may well be the reason why they're not in a position to cooperate with an investigation at the reasonable ground stage, because they haven't had the access to any of the recovery services. So I thought, oh, quite an interesting point. And then I went and checked. They know this. They've put this in their equality impact assessment. They are very well aware that this is going to indirectly discriminate against people who've got mental disabilities. So I think that this is something that we should be allowed to particularly as immigration practitioners, because we often will rely on the ECHR and ECAT in this context, but I think we need to be a bit more creative, because this act is so unprecedented in terms of the rollback on rights. And we know collectively from the litigation on detention, for example, Home Office is terrible when it comes to reasonable adjustments for people with mental disability, and it can't identify them, has no system in place, that it's probably going to be equally appalling in terms of its equality duties to victims of trafficking. So I think this is something that is potentially relevant in terms of how we think about litigating cases, either to say, my client cannot benefit from the carve-out at this time, and to withhold removal, suspension because of a disability is unlawful, or generally thinking about what other kinds of ways the Equality Act may also supplement our arguments on the ECHR and ECAT. And also I think it's clearly challengeable, because it's not proportionate. I mean, you see there that their legitimate aim here is to crack down on migratory crime. But this is also migratory crime, because you're talking about the inability of victims of trafficking to be able to participate in an investigation, because they're not have the wherewithal yet at that time. So one thing I think to just think about is medical expert evidence is obviously going to be really important in these cases anyway. But we may need to think about whether or not our experts need to also be addressing broader questions about victim capacity and also victim participation, because some of them will not be able to obviously participate at the very early time. So those are kind of the general issues, unfortunately, of these provisions. But I don't think that there's anything hopeful. I cannot, unless the only thing I could think of today, just in light of the discussion that Isaac and Ronan were having about remedies, is that, I mean, it seems to me in trafficking cases, we want to be trying to knock out return to your own country on the basis of, if you return me there, I'm going to be re-trafficked, and also it's a breach of ECAT and ECHR, see all my reasons, particularly if you've got a good state, of evidence in terms of Albania, China, Vietnam, etc. And also trying to create a suspensive claim around Rwanda. So having to analyse what are the risks of putting someone with positive RG in Rwanda. And that hasn't been litigated yet, because we've obviously been looking at general Article 3 for Rwanda, but that is something that's going to potentially become more important for these particular clients. So we may need to think about dissecting the note verbals and the C-pins on Rwanda through the guise of what happens to someone who's been trafficked in the past.
Well, it's 7:45. We've got a drink at the back there. We've got 15 minutes in which, if anyone would like to raise any issue or discuss anything, or have a drink.
I just have one question, which I'm not sure I can articulate well, but it's really to you actually.
Oh, hello.
Hi, I'm Kirsten. Hi. Does the local authority have any duties outside of being told by the laws what to do, even if they have a child in their care? They must seek to place them into their own accommodation.
Yeah.
But they already have that child. Is there nothing that continues towards that child if they concern their own mind? So the Home Office is overruling their age assessment, or their preliminary age assessment.
Yes.
Is there no duty of care somehow when they've already had them to continue to provide them with some form of protection?
So that's
like a social worker monitoring them in Home Office
so
accommodation.
so they would stay in the local authority care, but this was But then the Home Office can choose to exercise Section 17 and say, we'll give them to our Home Office children's homes in the meantime, and then we'll get the National Age Assessment Board to age assess them, because we're overruling your age assessment. And then, of course, if the National Age Assessment Board determines them to be an adult, they're already in Home Office child accommodation, so then they'll just move them to detention from.
And all duties from the local authority. They don't have any.
Yes, so but as long as that transfer has taken place. So I didn't go into the transfer too much, but that's all in Section 17. So if the Secretary of State directs a local authority to transfer, then it's all gone from the local authority, and now the responsibilities are all on the Secretary of State to arrange for accommodation. And then there's the question of, well, if they've been in that accommodation for how long, and they're still children, and the National Age Assessment Board decides they're children, would they then become an eligible child or a former relevant looked after child later down the line? Because that's not local authority care. Yeah, I don't know if that answers.
Should we have a little drink then?
Can I ask something? Sorry, I'm just thinking about people with criminal convictions. 'Cause, am I right? Rwanda won't accept people with criminal convictions.
Yeah.
Is that right? Because I was looking at papers from our surgery yesterday, and there was someone who had come last summer and claimed asylum, and then had been trafficked, but got a short prison sentence, which he's now served, and now he's got the usual stage 1 deport decision saying blah blah blah, raise asylum. But it just struck me he's in a better position than other people who got a notice of intent class.
My time as well.
Yeah, and I'm just wondering with this, I mean, we know it's unworkable in many respects, but is that also going to be the same for people with criminal convictions, especially people who are arriving and they're charging them with illegal entry and
because then they would all.
Yeah, I think that's Rwandan policy rather than.
Yeah, it is, isn't
what I
it?
mean? So I
But
think
they'd have to
arguably
get-
they can renegotiate. They would have to renegotiate that and get them to
accept.
agree to take. I think that's their general policy, but so you certainly have. The Home Office tells them if they have criminal convictions, and generally speaking, they don't accept any.
Yeah.
I think there's like in the agreement, there's like scope for them on a case-by-case basis to accept them anyway. So I guess they would try and in time persuade Rwanda to accept all of the people with criminal convictions. But yeah, it's an interesting. I hadn't really thought of that. Really.
And then, sorry, I had one other. Emma, do you? I don't know much about the public or disqualification stuff, but do you think if the current litigation is successful, is that a big setback for this, or does it sort of?
Yeah, definitely. So, you referred the Chris Butler challenge that dealt with the.
I don't. Yeah.
So there was a grant of generic
I
intervention.
thought that.
I think,
Yeah.
specifically because the regime didn't adequately factor in the risk of re-trafficking. So that's what the interim relief was based on. But I mean, I think Ronan, you've done lots of work on these cases as well. I think the pod system generally is contrary to Article 4 because Article 4 is an absolute obligation to identify. If the court accepts that the existing regime, which starts with automatic deports, is unlawful, then this would all be contingent. This would all have to go as well because it just relaxes the criteria to include people who've got less than 12 months sentences. So I mean, I think and there's lots of those cases. I think you're probably better speaking to that Ronan than I am, that are working their way through the courts at the minute for people who are in the existing definition of for national offenders.
That interim relief seemed like a positive sign.
Yeah. I mean, I don't think there's anything in ECAT or Article 4 that supports the withholding of a conclusive grounds decision. It's completely contrary to both instruments, and they're trying to import the notion of what Article 13 says about withholding a temporary residence permit, which is just about the recovery and reflection period. It's not even within Article 4. It's totally different. It doesn't talk about that. It talks about a positive obligation to identify actual victims. So hopefully these challenges do succeed because it seems completely unlawful.
Just thank you all. That
Yeah,
was
it's
very
amazing.
comprehensive.